Hi, welcome to another edition of our YouTube channel, and I believe you're all doing well and great. Well, as you all have heard about the news going on about the release of Mr. Nnamdi Kanu, the special counsel, Alo Ejimako, to the leader of the outlaw indigenous people of Biafra, IPOB, Nnamdi Kanu, has faulted the position of the Attorney General of the Federation, AGF, Abubakar Malami, on the court judgment ordering the release of the IPOB leader. The Court of Appeal in Abuja Thursday struck out the terrorism charges filed against Mr. Kanu by the Nigerian government and ordered his release from the custody of the State Security Service, SSS. It held that the IPOB leader was extraordinary rendition to Nigeria and that the action was a flagrant violation of the country's extradition treaty, also a breach of his fundamental human rights. But Mr. Malami, in a statement late Thursday by a spokesperson, Umar Gwandu, argued the Court of Appeal only discharged Mr. Kanu and did not acquit him. He hinted that the government will not release Mr. Kanu despite the court's ruling. The Attorney General said that the government is reviewing its legal options and could not institute other charges against the IPOB leader. He said that the decision of the Court of Appeal was on a single issue that borders on rendition. Let it be made clear to the general public that other issues that predate rendition on the basis of which Kanu jumped bail remain valid issues for judicial determination. The federal government will consider all available options open to us on judgment on rendition while pursuing determination of pre-rendition issues, Mr. Malami said. He said the government decision on the case will be announced to the public after the review of available legal options. But reacting to this, Mr. Ejimako said the AGF position on the court judgment was flatly wrong and perverse to both. He insisted that Mr. Kanu must be released first before any fresh charges against the IPOB leader. If the federal government refuses or stalls on releasing Kanu solely because it desires to levy further on its charges, it will amount to a burgeoning holding charge, which is impermissible under jurisprudence, he said. The lawyer explained that fresh charges cannot stick against the IPOB leader because in the present circumstances, the extraordinary rendition is an abiding factor that has created a permanent barrier to his prosecution. He said the trial of Mr. Kanu could not have proceeded if he had not been legally rendition. So it is not legally possible to lose jurisdiction in the extant charges and at once obtain jurisdiction in the next round of charges, Mr. Ejimako said. He said the judgment of the Court of Appeal has grandfathered a continued lack of prosecutorial jurisdiction that will, in the interim, be very hard to overcome. Meanwhile, human rights lawyer Inihibe Efeng had a similar argument stating that the government must release Mr. Kanu even if it decides to appeal the court ruling discharging and acquitting him. It is because the liberty of a citizen cannot be stayed. There is no room for stay of execution in this kind of case, he said. Thank you for listening and have a great weekend ahead. Bye.